Hello, you are welcome to this lecture. In this session, we are looking at Unit 2. Unit 2 is talking about the regulatory framework of auditing. Regulatory framework of auditing. And in this session, we are looking at Section 1, Auditor and the Ghana Companies Act. Auditor and the Ghana Companies Act. At the end of this session, you should be able to outline what the auditor is expected to report on and state who qualifies to be an auditor. Who qualifies to be an auditor? Um, the auditor. Keeping proper books of accounts. The keeping of proper books of accounts by every company is made obligatory by the Companies Act. Now, the proper books of accounts are not deemed to have been kept unless they portray a true and fair view of the state of the company's affairs. They explain transactions and enable the preparation of proper profit and loss account and the balance sheet. So if these are done well, then we say the books of accounts have been kept well. The books of accounts must be open at all times for inspection by the directors, the secretary, and auditors of the company. The books must generally contain a proper record of the financial affairs of the company, the changes in the financial position, and records with respect to the control of the accounting for all property acquired. Now, with regards to the proper book of accounts, in particular, the books must show details of all sums of money received and expended, and matters in respect of which the receipt and expenditure took place. All sales and purchases of property, goods, and services. Then the company's assets and liability and the interest of shareholders must all be detailed in the books of account. Now, in accordance with Section 131 of the Act, the auditor's report must be attached to every company's account before it can be circulated to its members. It therefore implies that every company should have an auditor so that the auditor's report can be attached to the company's accounts before it's then issued out. Now let's look at who qualifies to be an auditor. Now, for a person to qualify for appointment as an auditor of a private company, he must be a member of the Institute of Chartered Accountants under the Chartered Accountants Act 1963 at 170, or be a practicing accountant within the meaning of the said act, and must not have been disqualified by means of legislative instrument issued at the instance of the registrar. So there is a person who qualifies to be an auditor. Now, none of the following persons is entitled to act as an auditor to either a private or a public company. Now, an officer of the company or of any associated company cannot be an auditor of the company. Now, a person who is a partner or in the employment of an officer of the company or of any associated company, save that partnership with a person acting as a secretary or registration officer of the company or any associated company shall not constitute a disqualification. Now, An infant is also not entitled to act as an auditor. A person found by a competent court to be of unsound mind is also not qualified to be an auditor. Now, a body corporate, except that members of an incorporated partnership may be appointed. Then we have anyone in respect of whom an order has been made, and that Section 186 of the Act, so long as such orders remains in force, unless to act as auditor of the company, consent has been granted by the court in accordance with the said section. So if you have any cause in position, any verdict that imposed you or limits you, you can't hold any the position of what an auditor. Now, any person who is bankrupt, unless he or she have been granted leave to act as an auditor on the companies concerned by the court, which adjudged him bankrupt. So, if a court adjudged you to be bankrupt, you can't act as an auditor. You don't qualify as an auditor of a firm or of a client. So, as a result of that, you have to step down. But if the court give you some kind of relief, or they have granted you the relief, then you can now assume that position as an auditor. Now, who then appoints an auditor? Who appoints auditors? So, auditors are generally appointed by the shareholders or the members of a company at a general meeting by ordinary resolution. So, however, this is permissible for the auditors to appoint the first auditors of the company and fill any casual vacancy in the office of the auditor. The registrar of companies can also appoint for a company if the company shall have had no auditors for a continuous period of 3 months. So if the company is operating for a period of 3 months and there is no auditor, the directors were also not able to appoint any first auditor for the company, and the registrar of companies have the right to appoint auditor for the company. Now, who then fixes the remuneration of the auditors? Now, we say the auditor's remuneration is fixed by members of the company at a general meeting by an ordinary resolution or in such manner as the company may determine, because they are now the one engaging the services of the auditor. Now, members may accord the directors or the audit committee of the board the mandate to fix the auditor's remuneration. So whilst we were looking at the audit committee, we said that one responsibility of them or duties is to set or fix the remuneration of the auditors. They can do this if the shareholders give them the power to do so. Now, as far as an auditor can be appointed, there could be some instances where the auditor may be removed from office or he or she may resign. Now, let's look at the resignation of an auditor. If an auditor wishes to resign partway through their terms of office, they must carry out the following procedures. So, one, the auditor must deposit written notice of their resignation at the registered office of the company. Resignation is effective on the day the notice is received, unless the auditors have specified some later date. Now, the company must send a copy of the auditor's resignation notification and the statements of circumstances to the registrar of companies. Should the statements of the circumstances so dictate, further copies must be sent to all members and the debenture holders of the company and anyone else entitled to receive notice of general meetings. The fourth procedure is that the auditor may attach a signed requisition for the directors to convene an extraordinary general meeting in order that the circumstances surrounding the resignation can be brought to the attention of the members. Before the general meeting is convened, the auditor may request the company to circulate to its members a written statement of the circumstances of reasonable length. So those are the procedures that must be followed when the auditor wants to resign. The other way is that the auditor may be removed from office. He may be removed from office before his time. Now, for the removal of an auditor to have effect, the following conditions must be observed. So there must be a resolution to remove the auditor or to appoint another person in his place. The resolution must be passed at an annual general meeting of the company. Then, written notices of the intention to move the resolution must have been given to the company not less than 35 days before the annual general meeting, at which it is to be removed 14 days in the case of resolution affecting the removal or replacement of an auditor appointed by the directors. So 35 days before annual general meeting, and then 14 days in the case of resolution affecting the removal or replacement of the auditor who has been appointed by the directors. Now, on the receipt of this notice, the company shall forthwith arrange for a copy thereof to be sent to the auditor concerned. Now, the right of the auditor concerned to be heard on the resolution at the meeting must not be withheld. A notice of such resolution must be given by the company to its members at the same time and in the same manner as it gives notice of the meeting. Now, if this is not practicable, notice must be given to the members in the same manner as notices of the meetings are required to be given out not less than 21 days before the meeting, and 7 days where the notice relates to a resolution to remove and replace an auditor appointed by the directors. Now, removal of the auditor continued again. The court may, on application by the company or some other aggrieved person, decide against the circulation of the auditor's statement because it is considered to be unreasonably long or amount to an abuse of the right or an attempt to secure needless publicity of defamatory matter. Now, this is without prejudice to the auditor's right to be heard orally at the company meeting and to have his written statement read to the meeting if so required by him. So these are the procedures that must be followed if we want to remove the auditor from office. Now, other types of departure from office. Aside the resignation and removal, what are the other forms? An auditor may be removed from office by a resolution at the annual general meeting to appoint a new auditor. So special notice is required of such a resolution, and the auditor may, prior to the annual general meeting make representation as to why he or she thinks he or she should stay in office. Alternatively, an auditor may decline to offer himself or herself for re-election at the annual general meeting. Now, in these circumstances, the auditor can make representations about the resolution to appoint a new auditor prior to the general meeting at each at which that resolution is discussed. So there can be a resolution to remove the officer, or the auditor may not offer himself or herself for re-election again. Now let's look at the duties of the auditor. What is required of the auditor to do? Now, the auditor is required to make a report to the members of the company on all accounts and financial statements laid before the members at an annual general meeting, and to state whether the financial statements of the company or group of companies show a true and fair view and have been properly prepared in accordance with the provisions of the Act. It has to consider if any information in the director's report is consistent with the accounts and to report the fact if there are any of such instances. Now, the auditor has a duty to form an opinion as to whether proper accounting records have been kept by the company, proper returns adequate for their audit have been received from branches not visited by them in the case of a group account, and the company's balance sheet and its profit and loss account, they are in agreement with the accounting records and returns, and such information and explanations as he thinks necessary for the company's officers. He also has a duty to outline in his report the details of directors' remuneration, the loans to officers, transactions involving directors, and other connected persons, if not disclosed in the financial statement themselves. He also has a duty to make other special reports in various circumstances. Now, the auditor also has a duty to make statements of circumstances when he ceased to hold the office for any reason. These are the duties of the auditor. Now, what are the rights? The rights of auditors as laid by Section 136 of the Act. Now, he has a right of access at all times to the books of accounts and the vouchers of the company. He has a right to acquire from the officers, including the directors of the company, such information and explanation as deemed necessary for the performance of the auditor's duties. He has the right to attend any general meetings of the company and to receive notice of and other communications relating to any general meeting on any part of the business of the meeting which concerns them. Now, the auditor also have the right to apply to the court for direction in relation to any matter arising in connection with the performance of their functions under the Act, and to have the cost of any such applications met by the company, unless otherwise directed by the Act. The other duties or the other rights of the auditors are the right to be notified in writing in the event of an intended resolution to remove them or appoint some other person in their stead, to submit a written statement which must be circulated to members and be read, if so required, at general meeting. So if they want to remove him, he has the right to receive the notification. He also have the right, before accepting appointment as auditors of a company, to communicate with a retiring auditor, if any. So he has the right to consult these people to get in touch with the previous auditor, whether to accept the audit or not. So in summary, we've been able to look at what the auditor is expected to report on and the qualification of an auditor, the right and the duties of an auditor. So in the subsequent sections, we'll go deeper to look at the rest of the sessions in Unit 2. Thank you, and see you in the next section.